Welcome everyone to our webinar on sexual harassment, new employer duties under the workplace laws. My name is Saeidul Haque and I'm a Senior Associate in LegalVision's Employment and Health and Safety team. And I'm joined today by my colleague Lewis Njie, who is also part of the same team as a trainee solicitor. So before we begin, just a couple of quick housekeeping items today. So you receive a copy of the record and slides in your email. You can submit your questions in the Q&A box and we'll look to answer those towards the end of this webinar. And please also remember to complete the feedback survey that appears after this webinar. Also, all attendees are eligible to receive a free consultation from us to discuss how we can help you with your contracts or any of your other legal needs. To request your free consultation, please provide us with your contact details in the survey that appears at the end of the webinar. So in terms of today's topic, then we'll be talking about all things relating to the new laws around sexual harassment. So we'll be covering off what is sexual harassment and its existing forms, what is the current law, what the forthcoming changes are to the law and how that will affect you, how you can comply with the new law, and what the risks are associated with failing to comply with the new law as well. And as I said, just towards the end of the webinar, we will be looking to answer some of your questions. So please remember to submit them throughout this webinar through the chat function, and we'll look to cover those at the end. And now I'll talk about what sexual harassment is, how it occurs in the workplace, and what forms of sexual harassment also exist in the workplace as well. So what is sexual harassment? So sexual harassment in the workplace really is any unwanted physical, verbal, or non-verbal conduct of a sexual nature that violates someone's dignity or creates an environment that is intimidating, hostile, degrading, humiliating, or otherwise offensive. In terms of forms of sexual harassment, there are many forms, and some examples of this could include making inappropriate sexual comments or jokes to a colleague. It could include unwanted physical contact, like touching, hugging, even kissing as well. It could include staring or making offensive gestures of a sexual nature. And it can also include asking inappropriate questions about someone's sex life and also displaying offensive material. Now, when it comes to sexual harassment, it's important to think about how that can sort of come about in the workplace. So just by way of an example, let's say we have a situation, we have an employee called Jane who works in logistics, and there is a high volume of goods that pass through a warehouse where she works every day, which need to be correctly identified and labeled. Jane makes a mistake when labeling the boxes, which means that some of the work will need to be redone. And one of Jane's colleagues agrees to help her with this and correct the mistake. But while they're correcting the issue, the colleague begins asking inappropriate questions about Jane's sex life, which Jane feels uncomfortable to answer. Because of the nature of the questions asked by Jane's colleague, this could amount to sex discrimination because it is an unwarranted conversation about the employee's personal sex life. Other forms of sexual harassment can also include victimization. And an example of this is where someone experiences less favorable treatment because of how they've responded to previous sexual harassment. So for instance, let's say we've got a work social event and we have a manager who tries to make several sexual advances towards an employee, but the employee rejects them as this is not something they're comfortable with. The employee perhaps in this situation then speaks to the HR team or the HR manager about the incident, and the manager that is accused of this is spoken to by the HR team. Later on, the employee notices that the manager now ignores them and has started to treat them differently to other employees. The manager refuses to supervise the employee when they require supervision or any sort of assistance, which is part of the manager's role and what the manager still does with the remaining employees. So this is a prime example of victimization because the manager is only doing this because of the nature of allegations raised by that particular employee to the HR team. And I'll pass you on to my colleague Lewis to talk about what the current law is in relation to sexual harassment. Thank you.
Thanks, Saeidul. Yeah, so we've obviously explored now what is sexual harassment and what kind of forms it can take. But I suppose the important question is, what is the law at the moment? And that's going to better help us understand how those changes are going to be introduced and what they're going to mean for you. So first things first, we kind of see the development of the law in this particular area. We can see it in the Sex Discrimination Act in 1975, which was more recently repealed by the Equality Act 2010, which we seem to quite well understand and has got a household name for things like protected characteristics, your reasonable duties, and things like that. However, what is also encompassed in the Equality Act 2010 is harassment and sexual harassment. So this is defined in section 26, as you can see on the screen. And again, it just touches on the things that my colleague Saeidul was mentioning on. So the unwanted sexual acts that are creating a hostile or a humiliating environment and those sorts of things. And the important thing here is that, in short, it's classed as prohibited conduct under this act, and there are several things that can be done. So as of current, under the Equality Act 2010, an individual can make a claim in the tribunal based off sexual harassment, which is classified again as that prohibited conduct. And they can also report their employer to a body known as the Equality and Human Rights Commission. So this was a body established under the Equality Act 2006, and basically, in short, the purpose of this body was allow individuals, so employees, to report the employer to the Commission for failings in sexual harassment, and they have a whole host of powers which have been able to assist in this. So, for example, they can investigate any concerns that individuals might raise. They have other enforcement powers as well, such as making applications to the court or issuing unlawful act notices. And they can also work with the employer to implement plans for better future practice. And these are more commonly known as action plans. The upcoming changes, however, slightly change the way in which we tackle sexual harassment in the workplace. And the best way to describe this would be really describing it as kind of a reactive approach, where we react when a situation has occurred, to basically what's going to come into force in October this year, which is going to focus more on preventative steps, because prevention is always better than the cure. So what will this entail? Well, in short, under the Worker Protection Amendment of the Equality Act 2010, this 2024 amendment from October will now basically place new obligations on the employer, and they will, in short, become liable if they don't take reasonable steps to prevent sexual harassment from occurring in the workplace. So, what can this look like for you, and what will you need to demonstrate? Well, basically, you'll need to demonstrate that you're proactively taking preventative steps to ensure that sexual harassment is being prevented from occurring in the workplace. And the important thing here, once again, to signpost, is this will be irrespective of whether an incident has happened or not. And there will need to be evidence of a company-wide effort that steps are being taken to prevent sexual harassment from occurring. So just taking a step back from the law here, the kind of key themes and the key phrases that you're going to hear associated with this upcoming legal change is going to be that proactive, preventative steps and the company-wide effort. These are the things you're really going to hear in terms of where this law is seeking to take you as an employer in your obligations. Also, following on from this as well, the 2006 Act that we were speaking about a moment ago, that self-reporting tool to the EHRC, employees will still be able to do this irrespective of whether there's been an incident of sexual harassment or not. So, for example, if you don't have something in place or an individual feels uncomfortable, they can obviously go to the EHRC. So let's take a case study, for example. So Alice has been working at a large marketing firm for quite some time now, and they often have large social events outside of work time. Unfortunately, at one of the previous Christmas events, one employee in particular was sexually harassed by their manager. After this, the company had an internal procedure and they made an announcement that they were going to review their policies and create a safe space to make disclosures to try and prevent this from happening again in the future. However, the company did not end up implementing this, and Alice has raised this with them on several occasions, and there's been no movement in this area. Because the company has not done anything to address this issue, Alice feels uncomfortable about going to another social event, but also believes that the company does not have adequate measures in place, so she decides to make an application to the EHRC, and they subsequently investigate this matter. What I'm now going to do is hand over to my colleague Saeidul, who's going to speak a little bit more about how these upcoming changes come into effect and how, more importantly, you can comply with them as they become law.
Thank you very much, Lewis. So in terms of some proactive steps that you can take to comply with the new law, this could include, firstly, policies and procedures. So one thing you could consider is having a preventing sexual harassment policy, or just a general anti-harassment and bullying policy, which encompasses the company's stance on preventing harassment, including sexual harassment in the workplace, and what the company would do should instances of sexual harassment in the workplace occur. You could also include a policy such as equality, diversity, and inclusion. And this policy would really be there to promote equality in the workplace and prevent discrimination on the basis of sex. It can also be used to foster an inclusive and diverse environment in the workplace, and it would be compliant with existing equality laws as well, and ultimately promote the company's social impact reputation. You should also think about reporting channels to create a safe space for employees to make disclosures that won't adversely impact them. A failure to have a safe space to report concerns could foster a harmful environment for your employees, which could be in breach of your new obligations. Some reporting channels can include internal HR or internal management, whereby you can nominate an individual or a department to oversee any allegations of sexual harassment in the workplace. And this individual or department would essentially assume responsibility for investigating any concerns, identifying any steps that need to be taken to resolve the matter, and that could also include taking disciplinary action against the accused as well, which can lead to the termination of their employment, depending on the situation. And as my colleague touched on a moment ago, you can also consider contacting and liaising with third parties like the Equality and Human Rights Commission, commonly referred to as the EHRC as well. You should also look to demonstrate a company-wide effort to prevent sexual harassment from occurring in the workplace. And one way you can do this is through general risk assessments. Now, risk assessments is something you need to do legally as an employer if you have more than 5 employees from a health and safety perspective. But a general risk assessment can also be used for things like social events outside of work, or any sort of events perhaps where alcohol may be consumed. And this would be crucial to demonstrate that you have taken proactive steps, because it would show that you've actually thought about what may happen and what instances of sexual harassment may occur where there is an alcohol-fueled environment where these situations tend to materialize. You should also think about diversity and inclusion in the workplace. Having a more representative and inclusive environment in the workplace can go some way to preventing these types of instances occurring in the first place. And ultimately, you also want to make sure that you do investigate any allegations of sexual harassment in the workplace, and make sure that you do take any allegations very seriously. If, of course, you find there is not enough evidence to support a case, you should make sure that you just document your decision-making process in the event you are inspected or audited by the HRC, or you're held to account by the employment tribunal if an employee goes in that direction. You should also think about training your staff. So you could think about training for managers as well as employees on topics such as identifying sexual harassment, the reporting channels that I mentioned, prevention, and how you can assist the co-worker if they do make a disclosure about sexual harassment in the workplace, and just general good practice as well. With training, of course, you should also consider refresher training periodically. It's all good and well having the training once, but you need to make sure that you are taking those proactive steps, and having that refresher training, keeping it fresh in everyone's mind, can go some way to doing that. You can also think about employee assistance programs, or EAP in short, and these are effectively a confidential support service that can be provided by employers to help employees manage personal or work-related issues. And typically it offers access to counselling, advice and referrals to third parties at no cost to the employee. And this could include support on harassment or personal issues, for instance. Some employees ultimately may just feel more comfortable making disclosures to a third party rather than their employer. So this is why this can be encouraged. It's not a legal requirement, but it's certainly something to bear in mind. And as I say, would certainly demonstrate how you are complying with the changes. You should, however, try to encourage employees to raise any sort of instances of sexual harassment internally in the first instance, just to allow you to try and deal with that issue in accordance with your own policies and procedures. Finally, you should also think about frequent check-ins and e-meetings as well, particularly if you have lone workers or those who work from home as well. This is simply just to check in on their well-being and to see if your employees have any concerns. That could be part of an appraisal process, or it could just be a monthly check-in with your employees as well. Now, if any employees do have any concerns, you should make sure that they understand what your internal processes are and what reporting channels they can use as well, in case they are suffering with any sort of harassment in the workplace. And if they are, you should just make sure that you assure them that they will be supported so far as is reasonably practicable, and you will take any necessary action to prevent sexual harassment in the workplace as well. As I mentioned, if there is a perpetrator of sexual harassment in the workplace, it would be important to have an investigatory meeting with them with a view to potentially taking disciplinary action against them, depending on the situation. And sometimes that can lead to a sanction like a verbal warning, a written warning, which perhaps may send a message to other employees, or possibly even the termination of employment if there are severe instances of sexual harassment. And I'll pass you on to my colleague Lewis just to talk about what the risks are if you fail to comply with the new law. Thank you.
Thanks, Saeidul. And all of the above, as Saeidul mentioned, are really key here, again, to following those phrases that we'll be seeing with the proactive steps, the being, the preventative steps that can be taken. But let's say, you don't do this, or rather, what are the risks associated with failing to implement some of these measures that will definitely go a really long way to showing your compliance with the law? Well, there are several prongs in this, and there are kind of a lot of ramifications for an employer should they fail to comply with the changes. And it can be broken down into the following. So if you fail to comply with the Equality Act and the incoming changes, firstly, you might be subject to tribunal action. And this is where your employee can take you to the tribunal and bring forward a case. So they may seek to bring a case of sexual harassment, and the basis of that case, of course, would be that prohibited conduct, again, referring back to the Equality Act. Such claims would be used to determine whether or not an individual has been harassed, and if it was determined to be the case, the tribunal could consider the appropriate level of compensation. And they would be able to do this using the following bands that you can see on the screen, and these are referred to as the Vento bands. So on the more less serious cases of sexual harassment, what you can see here is at the bottom end of this, £1,200, and then that increases to £11,200, and those are for the less serious cases. For the more medium level, you've got £11,700 all the way up to £35,200, and then for your most gross failings, you've got £35,000 to £58,700, and those are the figures, and they change every year in April, so it's really important as well just to keep on top of that. This isn't kind of abstract or yes or no, however. It really depends on the basis of the claim and the severity of the incident that's occurred. And what you'll be able to see as well is in some instances where there's been a particular failure, what the tribunal may do is issue an award that exceeds the bracket of the most serious cases. And additionally, on the back of this as well, if an employment tribunal determines that an employee has been sexually harassed within the workplace and that you have failed to comply with your key obligations, on top of that award that may be provided to the employee, there's also that 25% uplift to the compensatory award as well. So from the first kind of element of ramifications from an employer's side, this can become very expensive. Moving forwards, however, we also have bigger issues as well, such as the reputation and public nature of tribunal proceedings, and this can cause great reputational damage to a business, particularly if a company is found to have failed in its obligations to prevent sexual harassment. Following on from this as well, I think a really important part to mention is if the failings have been so grossly committed by a particular individual, such as a manager or a HR or somebody in a director role, for example, and your actions or their lack of have significantly contributed to the incident that occurred, you can be held personally liable for that as well. So we've got two elements here. We've got the business responsibility, but in gross failings as well, what you can also see is that individuals can be held personally liable for that. So that's another thing to look out for as well. And then following off the back of what we spoke about earlier, and then moreover some of the reporting channels that Saeidul discussed, an employee will also be able to still make those disclosures to the EHRC, who again, as I mentioned earlier, may be able to intervene with things such as, an unlawful acts notice, an action plan, or they may issue a statement or something as such to get you to improve in an area that you particularly not took enough action from. But in short, those are the risks that are associated with failing to comply with the law, and it's really important that as we navigate this incoming change in the law, we really reflect and consider how best we can implement those measures to prevent this from happening. In conclusion, the incoming changes to preventing sexual harassment within the workplace will require the employer to take more effective steps. And again, it's just touching on the trope of today, which is really about that prevention and being able to strategize and implement steps such as policies, clear reporting channels, and risk assessments to ensure that you're being proactive and eliminating risks. But the key here is eliminating risks insofar as is reasonably practicable for your company with the resources that it has available. I suppose the most important point above all of this, though, is promoting a safe environment where people can feel safe and not have to worry about these things. And in the event that they do occur, having that recourse to be able to go, I know that there's internal reporting procedures or there's somebody I can speak to and a proper mechanism in place. With the increased risk of employers' responsibility or the individuals within a company being held responsible for failing to prevent sexual harassment from occurring, it is understandable how this incoming change and the flip from a reactive sense to a proactive sense can be quite daunting and question, how can I make this change? But by being proactive and thinking about prevention and implementing some of the steps that my colleague Saeidul mentioned, it's really be able to integrate these changes into your HR processes and encourage a safe practice, and most importantly, like I said a moment ago, a safer working environment. I hope that you have enjoyed our webinar today and that it's helped you simplify and explain some of those key changes coming into effect in October. And as the law aims to strengthen protection and clarify an employer's expected obligations, it is also crucial that you understand how to implement those key changes. If you have any further questions or require our help as well, please always feel free to reach out by completing the survey that will automatically generate at the end of the webinar to request your free consultation and how we can help you a little bit more. But to talk a little bit more about that, I'll pass you over to Saeidul.
Thank you very much, Lewis. So that concludes now the main part of our webinar, but you might find some information useful on our website where we have an article about sexual harassment and it provides some further more concise points on this topic. You can also download our free publication on how to hire and inspire in the UK, using the resources tab or by scanning the QR code shown on the screen. We also have an upcoming event that may be of interest to you on the 10th of September 2024 at 11 a.m. And that would be about hiring top talent and the legal strategies for small businesses. In terms of LegalVision, I'm going to go ahead and answer your questions shortly, but while you submit them, let's just take a minute to talk to you about our membership and what that includes. So by becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for all your business as usual legal needs, and our team can assist you with a wide range of matters, including unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, unlimited domestic trademark registrations, and much, much more. As a LegalVision member, you don't have to worry about the cost of lawyers ever again. Think of it as having your own in-house legal team. We'll take care of all the business as usual legal work, so you can focus on actually just running your business. So to learn more about how our membership can help you, please request a free consultation when the survey appears at the end of this webinar. And now we'll move on to answering some of your questions. So I can see a couple of questions pop through. So one of the questions that have come through what size businesses are covered by this new legislation? So that is an excellent question in terms of the size of the business. In short, there is no set, amount of the size of a business in terms of what this affects. This affects all businesses regardless of size. So even if you have 1 employee or if you have 100 employees, it's the same rules that apply from October for everyone. Sometimes there is slight difference in legislation in other things, like putting out a statement on things like equal pay. But for this particularly, there is no sort of minimum or maximum. It is applicable to everyone across the board. Hopefully that answers your question. I can see another one has come through as well, which says, what should I do if I witness sexual harassment in the workplace? So I'll pass this on to my colleague Lewis to answer.
Yeah, thank you, Saeidul. And just before I get into that one as well, just coming back from the question about what size businesses are covered, the key as well is doing so far as is reasonably practicable. It's all about what's reasonable to the size of your business and what resources can you reasonably expect to dedicate to changes in the law and things like that, just to touch on that a little bit more. But just coming back to the question that's come in about witnessing, what should I do if I witness sexual harassment in the workplace? Generally, if you witness sexual harassment happening in the workplace, you should report it to the HR department or a designated point of contact. And so if you're a smaller business and you don't necessarily have a dedicated HR department, it might be having that conversation with a manager or someone more senior in the business. And many organizations as well will have specific procedures when reporting such incidents. So there's things like staff handbooks or policies that might be on, your Microsoft SharePoint or things like that, for example, which would be worth just reviewing and seeing what those reporting channels are and if there's any support available there as well. But just bringing it back as well, you may also choose to support the victim by offering to be a witness if they decide to report the incident, and just being there as well for them as they go through that procedure with the company, because as it is understandable, it's a very daunting thing, and by being there, that can really support someone. I can see another one has come in as well, Saeidul, just about, can a single incident be considered sexual harassment, or does it have to be a pattern of behaviour? Do you want to take that one?
Sure, thank you, Lewis. So yeah, in terms of single incidents, whether they can be considered sexual harassment or not, it's a great question. And while sexual harassment often involves a pattern of behaviour, a single incident can be severe enough to constitute sexual harassment in the workplace, particularly if it involves things like physical touching, inappropriate comments, or it could even be a pattern of behaviour like seeking sexual favours in exchange for employment benefits, like a manager saying to a junior member of staff that in order to be promoted to a role, you need to provide a certain favour, and that's how you will get the promotion. Or the same could be applied to if an employee wanted to seek a salary increment as well. So, one-off things can amount to sexual harassment. And although a one-off act may be classed to be in the lower vento banding, it can sometimes go in the middle or upper banding depending on the type of conduct committed, particularly if it is quite a senior member of staff against a particularly junior member of staff as well. So it's very important to bear that in mind. And as my colleague touched on earlier, that companies as well as individuals personally can be held responsible for any sort of discrimination in the workplace. Lewis, I could see questions coming about how organisations can create a culture that sort of prevents sexual harassment in the workplace. So I'll allow you to tackle that one.
Yeah, sure. Thank you. Yeah, great question, firstly. And a lot of kind of what we touched on in today's webinar will be really helpful in addressing this one. So yeah, basically organizations can prevent sexual harassment by implementing clear policies, providing regular training, and establishing confidential reporting mechanisms. So things like clear reporting channels, some of the other kind of EAP things that Saeidul mentioned before, such as maybe third-party counselling or a kind of an external disclosure hotline, or those kind of company benefits as well. They all go a very long way to demonstrating this culture. Additionally, as well, a really important thing is making sure that investigations are conducted when complaints are raised, and doing this in a timely manner and in a way that acknowledges the concerns that are being raised. Because the most important thing here when you're trying to create a culture and why you're trying to genuinely display to your staff and your workforce that this is something that you don't want to be a part of your company's culture. It's about taking them seriously, and it's about showing them that you're willing to investigate this matter properly and explore what has happened and what needs to happen in the future to prevent that from happening again. So really important as well that we're thinking about considering complaints properly and having really effective procedures in place to show that consistency and seriousness when addressing any grievances that may be raised by an individual. So a really important one there, but also as well, model appropriate behaviour and promote a respectful and inclusive workplace culture. And that often as well starts at the top. So it's about managers, HR, directors, or senior staff as well, really setting those expectations and behaving in accordance with their own policies as well, and clearly showing from the offset what they expect if you want to be a member of this company that fosters a culture that focuses on making sure that sexual harassment doesn't have a place in it. So I hope that summarizes your question quite nicely. But I can see that the last question we've got come in: what constitutes sexual harassment in the workplace? I know you just took one for the single incident, so do you want to take this one as well, Saeidul?
Yeah, of course. Thank you, Lewis. I mean, when it comes down to sexual harassment in the workplace, it boils down to really the definition provided by the Equality Act, whereby someone makes unwanted advances, sexual advances, perhaps requests sexual favors or other verbal or physical conduct which is of a sexual nature, and that conduct ultimately creates an environment for that employee which is hostile and intimidating or offensive in some way, shape, or form to that particular individual. What we have to consider is ultimately no two employees are the same. So while one employee may not consider something to be intimidating, another may, and we have to make sure that we are sensitive to these particular issues as well. So in short, really, it can include comments made to someone, touching them, displaying offensive material, or even making decisions about their employment based on any sort of sexual conduct. Ultimately, sexual harassment doesn't have a place in any modern workplace, and it should be prevented so far as is reasonably practicable, because not doing so can have personal consequences for an individual or have consequences for a business. And financially, it can have, great impact, and non-financially, reputationally specifically, it can have a huge impact, as my colleague touched on earlier, because of the public nature of employment tribunal claims. So, ultimately, as my colleague pointed out before, prevention is better than the cure, better than the cure. So it's better to have all these policy and procedures in place, making sure that we actually do put them in place properly by having those training sessions, making sure employees are aware of how to report sexual harassment in the workplace, and ultimately stamp it out if such an incident occurs as well. So I think that is all the questions answered. So hopefully that covers off everyone's questions nicely. I'll just pass on to my colleague Lewis just to talk through the final viewpoints. Thank you.
Yeah, thank you. And so, yeah, just to wrap up, first and foremost, really thank you for taking time out of your day to join us this morning. And I hope that you found it a really useful resource to have that discussion today. If you'd like to follow any more of our work, or if you'd like to have a chat with us, you're more than welcome to. After the webinar ends, a survey will pop up, and we'd appreciate it if you could take some time just to complete that 30-second survey for us, and just include your contact details as well if you'd like to have a chat with us about anything in particular, or about how we can help your business with your forthcoming obligations, or if there's any more employment needs as well that you would like us to take a look at. In conclusion, that's all for today. And again, just make sure if you want that survey, just fill it out and have that consultation. But thank you for taking the time to talk to us. And I hope you have a lovely rest of your week.